Rule 7 deals with presidential guidance. Now this is guidance which deals with matters of practice and as to how the powers conferred by the rules may be exercised. However, although tribunals must have regard to such guidance, they're not bound by it, and a tribunal may lawfully fail to comply with the guidance, provided it's considered it. It must consider any guidance if it's there. Something that often catches litigants in person out are the time rules for doing things under these rules. If you have a look at Rule 4, you'll see what the basic rule is. An act required by the rules, a practice direction, or an order of the tribunal to be done on or by a particular day may be done at any time before midnight on that day. That's the basic rule. However, if you say you did the thing in time, you must be prepared to prove it, so keep a record. The next point to look at is what happens if the time specified ends on a day which isn't a working day. Well, the rules specify that the act is done in time if it's done on the next working day available. A working day means any day except Saturday or Sunday, Christmas Day, Good Friday or a bank holiday. So if the time would expire on Saturday and you do the thing by midnight Monday, you do it in time. Various forms of word indicate various methods of time calculation. So if a tribunal tells you that within a certain number of days of or from an event, you don't include the date of the event in the calculation. So suppose a response is due within 28 days of sending of the claim. So if the claim is sent on the 1st of October, you don't count the 1st of October in calculating the 28 days. Another form of wording that's often used, not less than a certain number of days before or after an event. Well, again, you don't include the date of the event in the calculation. So let's take presentations in writing for consideration at a hearing. Suppose you've got a hearing on the 8th of October. These must be presented by the 1st of October as at latest, because you don't include the date of the event, the hearing, in respect of which the calculation is made. So the presentations must be with the tribunal 7 days before the hearing. The tribunal is supposed to assist you, and the rules make this clear. If the tribunal imposes a time limit for doing any act, the last date for compliance shall, wherever practicable, be expressed as a calendar date. So look at what the Employment Tribunal said in the order or direction or whatever. Time specified by reference to the date when a document is sent by the tribunal is calculated as follows. Unless the contrary is proved, the date is deemed as the date endorsed on the document as the date of sending. Now, if there is no such endorsement, the date shown on the accompanying letter will be the date on which the document was sent. The moral is, read all correspondence carefully and diarise these dates. It is possible to extend time for doing things under the rule in most cases. Rule 5 deals with this, and essentially it says that the tribunal has a discretion. If you need to apply, do it in writing and explain why it is you need the extension. Don't simply ask for an extension, explain the need.